Here's a segment from a recent Gun Talk radio episode. You can listen to all the Gun Talk radio podcasts however you tune in, or check out guntalk.com for more. All right, we're rounding third and head towards home, going into the last hour, of the broadcast version of Gun Talk. Then we do, of course, the after show, which you can hear only through the podcast. Of course, we put the entire show up on the podcast, so if you miss a show, you can go back and hear it wherever you get your podcast. Easy enough, all right. The number here is 866-TALK-GUN, or just call me at Tom Talk Gun. If you want to follow what we're doing, go check out Gun Talk Media over on Facebook, YouTube, anywhere you get streaming video, there's a Gun Talk channel there. So we got a lot of ways to reach you and a lot of ways for you to stay informed. Glad that you're here. All right. I've been talking about this a lot. The movement is very much in our favor in terms of gun rights and legal cases, while at the same time, we've got a lot of states that are quickly trying to pass the most repressive gun control laws they can in the wake of the Bruen decision, basically flipping the bird at the Supreme Court, and understanding that they're almost all going to get tossed or knocked down. It's kind of a crazy time in gun rights, but it's a very invigorating and exciting, and frankly, I am very encouraged of what's going on. One of the guys on the very front row of all this, on the front line, if you will, is Adam Kraut. He's the executive director of the Second Amendment Foundation. He joins us right now. Adam, welcome. I know that you're a busy guy now. What you working on these days?
Hi, Tom. How are you doing today?
Good.
Good. Yeah, well, we got a lot going on our plate here with a number of different things related to gun stuff here at SAF. I mean, as you well know, I think the one you probably want to be talking about right now is ATF's recent final rule on the brace stuff.
Yeah, we waited for that for, I don't know, a couple of years, and they came out with their rule on the stabilizing braces, potentially, maybe actually turning millions of people into felons if they don't comply with this. Is that overstating the case?
No, I think that's probably really spot on. They released that final rule the Friday before SHOT Show started, so in somewhat traditional fashion, they waited until SHOT Show to release something that disrupts not only the industry but individuals as well. But yeah, I mean, they essentially in their rule went back and said that all these stabilizing brace-equipped firearms are now short barrel rifles, or always have been short barrel rifles, and gave a few different options for people to, come into compliance. The clock would start once it was published in the Federal Register, giving everybody 120 days to comply. It was published, I should have this off the top of my head, I want to say it was about a week or so ago. So that clock is already ticking. Right. And essentially what they said you could do, among other things, was you could remove the short barrel on it and add something that's over 16 inches in length. You could destroy the firearm. You could turn it into ATF. You could remove the brace and alter it in a manner that it would no longer be able to be reassembled or utilized, or alternatively, you could go and register the firearm in accordance with the National Firearms Act by filing a Form 1. For that, they were waiving or not applying the $200 tax that usually applies when making an NFA firearm. So that spawned, one would imagine, quite a bit of litigation already. I expect you'll see some more lawsuits, and this is something that SAF has had a challenge about since 2021, when they originally had released that point system worksheet.
Right.
So what we're going to be doing here is amending our complaint in the coming week or two to deal with the final rule itself. And our challenge is already, in a lot of ways, off and running. We just need to revisit the complaint and make some changes to deal with what exactly ATF had done.
Help me understand this. Didn't the ATF for years issue letters to manufacturers and to individuals and said, yes, stabilizing braces are not NFA items. They were perfectly fine. You could put them on your AR. Not a problem. We're okay with this.
Yeah, I mean, that's more or less the long and short of it. This all started about the time I entered the practice of law. So in 2014, the fall, spent quite a bit of time blogging about this exact issue. And they had originally released a number of letters to determination letters to manufacturers for products, the original of which became known as the SIG brace. That was a product of Alex Bosco, who owns SB Tactical, who I'm sure many of your listeners are familiar with for the wide plethora of stabilizing braces they have since created for other firearms. But yeah, for years they said that this is fine. Then they released that open letter that talked about shouldering, and you couldn't do that. And they went back and released another open letter saying, well, incidental touching is okay, but these things are not. It just created a lot of confusion along the way, which ultimately culminated with them coming back and saying, stabilizing braces, no, we're just not going to do it. And here we are today.
Several people have asked, a lot of people have asked the question of, well, only Congress can make laws. How can the ATF issue rules or regulations that have the weight of law?
Well, that's a good question. So the ATF, along with any other regulatory agency, is part of the executive branch. So when we're talking about our government, we have three co-equal branches of government. You have the executive, which falls under the presidency. You have the legislative, which would be Congress, and then you have the judicial, which is, of course, all the courts. When Congress creates law, or actually writes law, part of what they did with the Administrative Procedures Act was delegate some of the interpretation to these executive agencies because they're supposed to house expertise that Congress doesn't. So interpreting what Congress did within the confines of how the statute was written is something that they are permitted to do, but they're not allowed to just create new law out of whole cloth. So using the bump stocks as the example, because that was one of the more recent ones, and there was a decision out of the Fifth Circuit not too long ago. ATF in that essentially looked at the definition of machine gun and said, not good enough, and rewrote the definition of machine gun. And as many people are aware, the Fifth Circuit finally came back with a decision that said, no, you just can't rewrite a determination or rewrite law like that. So there is some room for administrative agencies like ATF, EPA and others that are out there to interpret what Congress has written and create regulations that are consistent with what Congress did, but it doesn't give them the ability to go beyond what Congress wrote as law and create new law and boundaries that didn't exist.
Adam, I'm seeing, and this is connected but a little bit different, I'm seeing this decision out of the Fifth Circuit on that. I'm seeing the decision on where the court said if you're a user of marijuana, you're not disqualified from owning a gun, overturning that. We're seeing the decision that just came out this week where they said a restraining order for domestic violence is not constitutional to tell you can't own a gun. It feels to me as though the winds have changed and we've got them kind of at our back, and we're getting the courts to make a lot of these kind of decisions. Is this all a part of the post-Bruen world?
Yeah, I think that is all part of the post-Bruen world. That decision about the marijuana, that actually came out of a district court in the 10th Circuit. That was in relation to a motion to dismiss criminal charges against somebody. The Fifth Circuit stuff, again, most recently the bump stock one. If you look at what Bruen said, and I believe we've talked about this before on your program, but if not, all Bruen did was, other than very explicitly say there is a right to bear arms outside the home, which was, by the way, also previously said in Heller, it said, we already told you what the test for Second Amendment stuff was, and that's text as informed by this nation's history and tradition. And to make sure that everybody was on the same page, the court not only said it once, but it said it twice. And it said that it's the government's burden to show that there is a historical regulation or law that is either the same or analogous to the modern day one in order for a court to find that it is constitutionally permissible to have that limit on the right to keep and bear arms. Mm-hmm. So, Yeah, I mean, in a lot of ways, yes, because the courts for years had applied that two-step where first, it doesn't involve the Second Amendment. If yes, then let's go and see what interest balancing we can do, and it can't be rational basis, which is the lowest level. And they almost always chose intermediate scrutiny, and they almost always said, government has an interest in regulating this conduct for the public good, and thus, government wins. So,
in other words, they said, yes, it violates the Second Amendment, but we're okay with that because we think we should do that for the greater good.
Yeah, well, interest balancing, right? The government's interest is good enough, so yes. We're fine with it. I think a lot of it is in relation to Bruen, and Bruen really solidifying that this is the test, this is what you need to do. And you're even seeing judges that you might not have previously expected who were appointed by, Democratic presidents coming in and finding laws to be unconstitutional.
Right. Let me ask you this. You mentioned the Fifth Circuit decision on bump stocks, saying that they can't outlaw those. Does that mean that bump stocks are legal now?
Well, that's a very good question, right? The question I think that remains, and the one I'm not going to provide an answer to everybody in, is whether that just applies to the plaintiffs and the organizations. And I can't recall. I don't think there were any organizations actually involved in that lawsuit or not, or whether it applies to everybody and it's a nationwide injunction. There tends to be some back and forth between lawyers on some of this stuff. The real question, I think, is going to be whether the government appeals that decision or applies for, a petition for certiorari to the Supreme Court. That could have, wide sweeping implications across the country if they do. Otherwise, it, in theory, could be confined just to the Fifth Circuit.
And I think there's the Potion case, I think in the 10th Circuit, it's probably going to be relooked at on the basis of this. The same firm that did the Fifth Circuit case is handling that one. So I think we're going to go back and get another bite at the apple on that one. I'm hoping it all ends up at the Supreme Court and they come back and say, we told you this. Now we're going to tell you one more time. Don't come make us do this again. Yeah,
there were a couple of bump stock cases that are still percolating their way up. I know the one that I was a part of, under my prior employer that I started in private practice. That one's still sitting in the D.C. Circuit. I think there's another one that's still in the D.C. Circuit as well that hasn't yet tapped out on the en banc panel anyway. So I suspect you'll see a few more of those potentially, on their way back to the Supreme Court if there's negative decisions out of those.
Well, let's do this, Adam. If you would, please keep us posted on the stabilizing brace case. And when you file the suit or reactivate the case on that, the file, let's talk about that. And because people are wanting to know, I mean, we have millions upon millions of people who have these things, and they're saying, what should I do? And right now I'm telling them, don't do anything. Let's wait and see what happens in the courts. You have 4 months, 120 days on this thing, so don't be rash and hasty, right?
Yeah, and the one thing I would point out with our lawsuit is we already have a time frame established for briefing on the preliminary injunction issue with the government that would allow the district court to render a decision and for us to be up on appeal one way or the other prior to the effective date. So we're going to be moving quickly in our case to, try to vindicate everybody's rights on it.
There you go. Appreciate that. And Adam, thank you so much. I'll direct people to the Second Amendment Foundation, SAF.org. Frankly, getting it done big time, like 50 lawsuits involved with at least that many right now. Adam Kraut is the executive director. Adam, thank you again. I appreciate that. All right, we're open lines now. If there's a gun you want to talk about, you want to give me a range report, you've been out doing some shooting, you bought a new gun, you're thinking about getting into reloading. If you got any questions about that, I'm happy to answer that as well. Our number is 866-TALK-GUN.